You ready, Lori?
We are recording.
Okay. Good afternoon, everyone. Welcome to the appellate court. Judge Bright, I'm sitting with Judge Albert and Judge Devlin on the matter of Fernandez versus Mack Motors, Inc., AC docket number is 43618. This argument is being conducted over the Teams platform, so everyone's appearing by video conference. In addition, it is being streamed live over the branch's YouTube channel. I'm going to ask everyone to identify themselves just to make sure we can all see and hear each other okay. I'll start with the judges, then counsel for the appellant and counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Albert. Good afternoon.
I'm Judge Devlin.
Good afternoon, Your Honors. James Sabatini for Ms. Fernandez.
And good afternoon, Your Honors. Sarah Simeonidis from Jackson Lewis for the defendant, Mack Motors.
Okay, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. If you get disconnected for whatever reason, please log back on and click on the link and rejoin the argument. We will suspend the argument until we make sure we have everyone present. I'm going to ask everyone to keep your microphones muted during the argument to cut down on feedback and background noises. The judges will do the same. If we have questions, we're going to raise our hands and ask that you recognize us. If you don't, for whatever reason, we'll just jump in like we would in the courtroom. But again, we're trying to cut down on the background noise. We would ask everyone to keep your cameras on at all times so we can make sure you're present and appropriately engaged. And I'll remind everyone that although we are all doing this remotely, this is a courtroom proceeding and everyone should conduct themselves as if we were all in the courtroom at 75 Elm Street here in Hartford. I will keep time for the arguments. We don't have our light system available, so I will hold up a sign at 2 minutes, at 1 minute, and when time is up. Each side will have 20 minutes. The appellant can reserve some time for rebuttal. Attorney Sabatini, are you ready to proceed?
Yes, Your Honor.
All right. How much time do you want to reserve for rebuttal?
2 minutes, Your Honor.
Okay. You may proceed.
Thank you. May it please the court, I'm James Sabatini. I represent Ms. Fernandez. I want to first address the hostile work environment claim. Some judges might find the incidents that Ms. Fernandez was subjected to in defendant's workplace insufficient to establish a hostile work environment claim under our Fair Employment Practices Act. It is equally certain, however, that many other reasonable people, judges and non-judges alike, would consider these incidents entirely sufficient to satisfy the relevant legal standard. The inquiry is an objective one. The subjective component having been met already by Ms. Fernandez. In this particular context especially, what a reasonable person would consider sufficiently severe under the relevant legal standard has changed over time. Let me explain. Norms may have been different 10 or even 5 years ago, but today many reasonable people would consider it deeply offensive, severe, abusive, pervasive to be working in a workplace where multiple male managers are referring to women as whores and bitches, talk about oral sex, grab a female employee's rear end, comment on a female employee's breasts, invade that female employee's personal space, and yell at that female employee to such an extreme as to cause spit to fly out of his mouth. Yes.
Attorney Sabatini, was there any what is in the record which describes the frequency with which this conduct occurred?
In the brief, Ms. Fernandez cites to portions of her deposition testimony where, while she doesn't identify the exact number of times, it is clear from her testimony that the derogatory language used, not by one manager, including the GM, but multiple managers, these were not one-off occasions. That derogatory language was commonly used when talking about women in this workplace.
So, Attorney Sabatini, when Judge Peck states plaintiff failed to submit any evidence concerning the frequency and pervasiveness of such language, is it your position that that's just simply a misconstruction of the record?
Correct. That while Ms. Fernandez did not testify as to the exact number of instances she was subjected to an abusive workplace, it is clear from a fair reading of her testimony that there were multiple instances where she was exposed to this abusive workplace that was gender specific. I mean, even, to play devil's advocate for a moment, let's assume that the general manager, Mr. Webster, only called women whores once, only called women bitches once, and only grabbed a female employee's rear end once. Okay, but there are other managers. There was another manager, for example, that referred to Ms. Fernandez or another female employee as a, quote, biatch, end of quote. His explanation for that, if you want to call it word, was it was a fancier word for bitch. We also know that it wasn't just Mr. Webster, the GM, that invaded Ms. Fernandez's personal space and yelled in her face to the point where spit was coming out of his mouth. There was another manager, a McAllister, that did the same type of conduct. So in this record, there are a number of what Ms. Fernandez would classify as severe instances of abusive behavior. Yes, Judge Bryant.
So are you familiar with the Feliciano versus AutoZone case, which was a case from our Supreme Court in 2015? Neither side cited it, which discussed whether the trial court properly granted summary judgment in a hostile work environment case. And it involved incidents similar to what you've described over a 3-month period that the plaintiff worked at AutoZone. And I guess I wanted to know, if you're familiar with the case, how the record in this case compares with the facts in AutoZone, in Feliciano, which led our Supreme Court to say that the trial court erred in granting summary judgment.
Judge Bright, I'm familiar with the name of the case. I'm not familiar with the details of that case at this time, Your Honor.
Fair enough. Okay.
By today's standards, the conduct that Ms. Fernandez was subjected to is reasonably seen by many as going far beyond mere bad manners, impolite language, or verbal roughhousing. Whether an employer, I should say, is guilty of a hostile work environment under our Fair Employment Practices Act should not be tethered to standards of conduct frozen in time. Yes, Judge Bright.
So if you're talking about the point in time, are we talking about April 2021, or are we talking about February of 2016 when she resigned, or was, in your words, constructively discharged?
Good question, Judge. Actually thought about that earlier today in thinking about the jury instruction on that topic and whether the jury would be instructed to consider it in present time or the norms in 2016. I don't have a definitive answer for that question. I would submit, though, that 2016 and 2021 close enough period of time where the norms likely haven't significantly changed.
Really? You don't think in the last couple of years the norms have changed significantly with the Me Too movement? And
yes, with the Me Too movement, I guess, yes, I would agree. I would agree. You know, I just don't know the answer in terms of, you know, the jury instruction. I would find it difficult to ask a jury to weigh the evidence in light of the norms that existed in 2016. As I think about this more, I believe the jury would be tasked to consider whether or not this workplace was abusive in present time.
Attorney Sabatini, so a foundational aspect of your position that the workplace was abusive appears to be that the managers referred to women as not being great drivers and not decision makers when buying a car. Is that correct?
Yes. And I will explain why, as a part of her evidence, she's including that to make out her hostile work environment claim, because the law does not require, and the law recognizes that a workplace can be abusive towards women, even if the abuse is not sexual in nature. Now, some of the abuse that Ms. Fernandez was subjected to was sexual in nature.
I'm just having real trouble with a comment on who makes decisions right, and this comment could be completely wrong, on who makes decisions in a car buying situation and who is a better or worse driver. That doesn't seem to get anywhere into an even broad realm of hostility.
Right. So if we, Your Honor, if we take each of those remarks and isolate them and view them in isolation, yes, they don't amount to much of anything. But we can't look at those remarks in isolation. We must look at those remarks in the context of the other remarks made by the male managers, the other conduct from the other male managers. And when we do that, we can draw a reasonable inference that those remarks come from a place of gender bias or gender stereotyping. For example, the stereotype that when it comes to important decisions of finance in the household, that's a decision for the man to make. Or the stereotype that male drivers are superior to female drivers. So when we review the misconduct from these male managers, these two instances have probative value in establishing an abusive workplace. What constitutes an abusive workplace based on sex evolves over time, and it's for the jury of Ms. Fernandez's peers to decide whether this defendant's workplace violates today's standards. Or stated differently, Your Honors. Yes, Judge Devlin.
I'd like to go back to your comment that it would be present-day norms that would influence the jury's decision about that. I mean, wouldn't it be the time frame that the plaintiff experienced it? Wouldn't that be the relevant time frame in determining whether she experienced a hostile work environment or not? And not 10 years before, and not 10 years after.
I understand. Yes, Judge, I understand that question. It's a difficult question because on one hand, yes, there's some tension. What was acceptable or unacceptable behavior? You can make a case that has to be evaluated during the time it was taking place. On the other hand, if we're asking a jury to decide whether or not this amounted to an abusive workplace, is it feasible to ask a jury in 2021 to make this decision by applying what they thought were the norms in 2016? I'm not sure a jury. Yes, Judge. Right.
Don't we do that all the time in medical malpractice cases? Don't we say that you have to judge the performance of the doctor based upon what the standard of care was at the time the services were being rendered? Because things change over time in the medical profession too.
Yes. However, the difference between the two cases is that in a med mal case, we have expert testimony that's actually required from the plaintiff to establish the relevant standard of care and in which way or ways did the healthcare provider deviate from that standard of care. In a hostile work environment claim, expert testimony on this objective component of the legal standard is certainly not required. So I think that's the distinguishment between the two types of cases. Another way to look at Judge Peck's decision is as follows. If the jury returned a plaintiff's verdict on Ms. Fernandez's hostile work environment claim, would the trial court have been required to set aside the jury's verdict and enter a judgment for the defendant on the hostile work environment claim? Ms. Fernandez says no and submits that this court agree with her and reverse Judge Peck's decision with regards to the hostile work environment claim. I ran out of time for the gender discrimination claim.
All right, you'll have 3 minutes left for your rebuttal.
Thank you.
Attorney Simeonidis, you ready to go?
Simeonidis, Your Honor. Thank you very much. May it please the court. Good afternoon. Again, I'm Sarah Simeonidis for the defendant appellee, Mack Motors Incorporated, which is doing business as Hartford Toyota, and that's how I will refer to them today. Your Honor, ultimately, this court doesn't even need to grapple with what Mr. Sabatini claims is a difficult decision on whether the hostile work environment claim should have been submitted to a jury. Ultimately, Mack Motors, Hartford Toyota's entire position is that summary judgment can be affirmed on all claims on the basis of res judicata. Plaintiff, to her detriment, chose to split her claims between the federal court when she filed her Equal Pay Act claim, and then subsequently the state court when she filed her gender discrimination and her hostile work environment claims under SFIPA here in our state courts. The entire crux of the res judicata doctrine is to prevent what plaintiff has done here, which is split claims and essentially forum shop to bring particular claims in a forum where she thinks they will be most advantageous for her. Once plaintiff brought her federal court claims to conclusion in a final judgment, which we did have through Judge Underhill's decision to grant summary judgment on plaintiff's Equal Pay Act claim, that distinguished her right and her ability to then have these state court claims heard in a different forum. In her brief, plaintiff raises two principal arguments why the res judicata doctrine should not apply here. First, she argues that her claims that she brought in federal court were quote unquote fundamentally different than her claims here. And then she argues that there was a jurisdictional bar that prevented her from bringing all of those claims at one time in one forum. And both of those arguments are unavailing. The res judicata doctrine provides specifically that a plaintiff is barred from litigating claims that she actually brought to final judgment or could have brought in that prior forum. And so once plaintiff raised her employment claim of Equal Pay Act in the federal court, she was required to bring any and all claims relating to that same transaction or series of transactions that occurred between herself and her prior employer, Hartford Toyota. It doesn't matter if one claim has a different standard. Yes, Your Honor.
Is it the same series of transactions? If the claim on the Equal Pay Act claim is that this pay plan that was put into place in 2016 was discriminatory and constituted a violation of the Equal Pay Act, is that the same constellation of facts as the hostile work environment claim, which relates to 2 years of mistreatment by other employees unrelated to the pay plan?
So, Your Honor, the standard actually is even a little bit more broad than I just stated it about the same transaction or series of transactions. What the restatement second of judgments tells us is that any claims that could have been raised in that prior action where the original court would have had jurisdiction and would have likely exercised jurisdiction should be brought in the original action. And that is clear here, right? Here we had two sets of litigation regarding issues that occurred during the course of plaintiff's 18 months of employment. We had in both cases the exact same parties. We had the exact same actors. Most of the allegations involved the general manager, and we had a lot of the same proof and allegations that were made by plaintiff in both actions. And so even though her hostile work environment claim is a different legal theory of discrimination than her Equal Pay Act claim, it is still extinguished because she had the opportunity to bring that claim in the federal court. The federal court would have had pendant jurisdiction over that claim. And the standard is whether this court can say that the federal court very clearly would not have exercised that jurisdiction in order for res judicata not to apply. And here there's no basis for finding that. Our federal courts exercise supplementary jurisdiction over SFIPA claims, including gender discrimination, sex harassment, and hostile work environment every day. And so there's no basis to conclude that the federal court would not have had that jurisdiction. And we cite a case in our brief, Your Honor. It's Bajorlin versus MacArthur Equities. This was a District of Connecticut court case by Judge Shea. And it is actually the exact same factual scenario as this case here. except that the state court judgment came to judgment first, the state court action. But in that case, we had a plaintiff who brought a federal Equal Pay Act claim in federal court and then brought her SFIPA claims in state court. The SFIPA claims went to judgment first on a default judgment, and Judge Shea found, analyzing Connecticut state law and the principles under the restatement second of judgments, that plaintiff at her own risk separated those claims into two separate forums, and once judgment entered in the state court, she was then precluded from proceeding on her Equal Pay Act claim in the federal court because all of those claims could have and should have been brought in in the same forum, regardless of whether there are different damages or different, additional facts that you might present or, come under different legal theories. So, here plaintiff had the opportunity to do that. She commenced both actions at very similar times. There was no jurisdictional bar preventing plaintiff from bringing those SFIPA claims before the federal court. While certainly she was required to exhaust her administrative remedies, she still had plenty of time once she filed her complaint in the Connecticut Commission on Human Rights to get that release of jurisdiction and still amend her complaint in the federal court to include the state law claims, and she elected not to do so. To ignore res judicata in a case like this would be to encourage plaintiffs from doing exactly this, which is filing 2, 3, or more complaints with different legal theories in each complaint so that they could get, yes, Your Honor.
So is your position then that to the extent she had any claim arising out of her employment with Mack Motors, that had to be included even if it related to a different set of facts?
Yes, Your Honor.
So if she was assaulted on the premises by somebody and had a claim for assault, she would have to bring that assault claim as with her equal pay claim.
Your Honor, if in your factual scenario the assault was by some third party and was not part and parcel to her,
no, let's say it was assault by the manager.
Your Honor, unless there's a public policy exception that would preclude the use of res judicata in that situation, then yes, I think our precedent does say that. Can you point me to a case which says that even where you're dealing with a different constellation of facts and a different transaction, if it involves the same parties occurring during the same period of time, you have to bring them or res judicata would preclude the claim? Sure, Your Honor. So there's a case, and I believe it was actually cited by plaintiff in his brief, Fink, and I'll get the last name in a moment from my brief.
Fink versus
yes, thank you, Your Honor. And in that case, the court precluded claims in a second suit. So the first lawsuit that was brought involved breach of employment contract and a non-compete that had been decided in arbitration. The subsequent litigation was a derivative lawsuit alleging conversion, tortious interference, unjust enrichment, and cutba. And so even though they were technically discrete legal claims that certainly involved in some aspects different actors and different allegations, because all of those claims could have been brought in one forum at the same time and would have convened a convenient trial, set of facts for trial, a trial unit, then the court held that res judicata applied. Our Connecticut Supreme Court and this court has applied res judicata numerous times, even when there are distinct legal theories being applied as between the two separate sets of litigation. Here, we don't have a case that is as distinct as Your Honor's scenario where we have a physical assault type case where we would traditionally think of bringing that in state court. And that might be the type of claim that a federal court would choose not to exercise supplementary jurisdiction over. But here, it's very clear that our federal courts are capable and frequently bring in state court claims in the context of Equal Pay Act claim litigation. And so I think our federal court was more than competent to decide the hostile work environment claim, and plaintiff could have had her day in court before a jury had she brought that claim in the federal court and had the court, had that claim survived a summary judgment motion on the court. by the court, rather.
So
Attorney Simeonidis, I just have a question. How do you account for the possibility that the federal court may decline to exercise jurisdiction over what that court may see as a different factual scenario than in this situation in equal pay scenario?
If the court had declined to exercise that supplemental jurisdiction, then at that point, the plaintiff would have been free to bring her claim in state court. There would have been no res judicata bar from doing so. And my understanding, Your Honor, is that the statute of limitation tolls for the period that claim is before the federal court and until such time as the federal court refuses to exercise jurisdiction, so that the plaintiff is not precluded by timing or any other factor to then bring that claim in state court if the federal court declines it.
Did you argue this to Judge Peck and she declined to decide the summary judgment motion on this basis?
No, Your Honor, she didn't decide to, she didn't deny summary judgment on that basis. Unfortunately, the issue was not really fully presented or fully flushed out, I think, so that Judge Peck understood the argument, which is why we've made it more clearly here, Your Honor.
So you didn't raise this with her?
No. And this is something, Your Honor, that the court can decide sua sponte, and we do have case law for that position in our brief. Judge Bright, did you have a question before I go on?
I did have I was going to move on from the res judicata, so
okay.
I don't know if Judge Albert or Judge
Nope,
Yellen have questions about that.
Yeah, about that.
I was going to ask you the same question I asked Attorney Sabatini about Feliciano and whether you're familiar with Feliciano, because you don't discuss it in your brief either, and how the record in this case is different than the record in Feliciano.
Agreed, Your Honor. I would argue that the record in Feliciano is much more severe than the record that is presented here by Ms. Fernandez. Their plaintiff was touched physically, rubbed up against at least 3 times. When she complained about it, she was called a bitch. She was ridiculed publicly about her femininity and her hairstyle and referred to as a man, and her complaints were not taken seriously. In contrast here, we have a situation where plaintiff had what she characterized as a few or several tense arguments with a male colleague over a work issue. And yes, if he got in her face physically close to her, you know, it's certainly not how I would want to be treated at work, but that is not the standard. She was never touched in any way. When I asked her specifically in deposition whether she had ever been spoken to in any derogatory terms or ever felt that she was specifically harassed sexually, she was adamant that that had never happened and that if anyone had done that to her, they wouldn't have lived to see another day. This is a situation where the crux of plaintiff's hostile work environment claim is that she had a few verbal altercations with her boss, and that there was some background noise about female drivers and some stuff going on at the dealership. To some of the questions that were asked earlier of Attorney Sabatini, plaintiff doesn't provide any context in the record for how frequently these things happen, how severe these comments were when they were actually made. In fact, she identifies the general manager, Jim Webster, as the kind of primary instigator of this type of language, and yet she admits in deposition that she had very little contact with him in her day-to-day activities because he would have been out on the sale floor and she would have been back in the finance department doing her own work, which again is further supported by the fact that she only identifies a few instances where she had these uncomfortable interactions with him. While I certainly agree that those types of stereotypes about women drivers and who makes the, financing decision are outdated, I don't believe, and I don't think the case law supports, that they would contribute to a hostile work environment, particularly when we have no idea whether it was said one time, whether it was ever said in plaintiff's presence, and whether rather it was something that she was being bombarded with on a daily basis, like she now alleges. Plaintiff's tries to generalize in her brief and talk about managers and multiple issues, but it's really clear that the context of her complaint is against her general manager. And then she brings up this one kind of side issue that occurred with another manager calling a female employee a biatch, which in the context of his deposition testimony, he explained was kind of a, like a joking around slang type term because they were jabbing with each other. In plaintiff's deposition, she never even said whether she had heard that comment ever made. So plaintiff is trying to kind of piggyback in a few discrete things that may have happened at work without providing any context for whether she had ever heard those things happen, whether she personally was offended by a comment like that, and whether, and the key issue here is whether under the totality of the circumstances, those couple of things that were going on in the context of a car dealership in 2016, and I do think the context and the year is important here, whether those things altered her working environment. And I think the answer to all of those questions is no. Plaintiff never yes, Your Honor.
So when you say the work environment, are you saying that the standard for what is acceptable behavior and what might cross the line in the hostile work environment can depend on the type of business it is? So a car dealership, you get away with more stuff than you might in a law firm?
No, Your Honor. No, certainly not. But I do think, and even the Supreme Court recognized in Uncali, that you do have to view things somewhat within a social context. And so, if at a law firm I made comments about female clients, that might be perceived differently than a car dealer making a comment about a female driver not being the decision maker. And so, the context does play somewhat of a role in that particular instance, I think. But in any event, I think it's clear, and plaintiff never alleges or establishes that any of these little isolated issues that she's trying to lump in to create a hostile work environment claim actually altered her work environment for the worse. And the easy answer here is they did not. This was a very well-paid, respected employee who only quit when she thought that her compensation was going to be negatively impacted. She never complained about any of this hostile work environment or abusive behavior to anyone. And so to now say that it caused, a material, change in her work environment for the worse is just not appropriate and is not correct. I would say, Your Honors, that Judge Peck's decision, just to sum up, on res judicata in particular to the gender discrimination claim was proper, should be affirmed. Those claims very closely mirrored one another. I do think that on appeal, this court can also affirm the judgment as a whole on res judicata grounds. And even if the court does not do that, neither her constructive discharge claim nor her hostile work environment claim are supported by the record and the case law as it existed in 2016, 2010, or today, regardless of whatever standards that Attorney Sabatini thinks the court should be looking at in terms of the appropriate timeline. We would ask that the court affirm Judge Peck's decision in its entirety.
All right, thank you very much. Attorney Sabatini, you have 3 minutes. You're on mute, Attorney Sabatini.
Res judicata was not a basis in which the court granted summary judgment on the hostile work environment account. In fact, the defendant didn't even move for summary judgment on that count on the basis of res judicata. Ms. Fernandez would submit the reason why the defendant chose not to do so is because the defendant recognized that res judicata did not bar the hostile work environment claim. The hostile work environment claim relies on a completely different set of facts and transactions and legal elements than the EPA claim. And there's a practical reason why the EPA claim was filed in federal court when it was. That is because there is a 2-year statute of limitations for that federal claim to be filed. The discrimination and harassment claims brought under the Fair Employment Practices Act can't be directly filed in court. They have to be first filed administratively with the CHRO, which is what Ms. Fernandez did. The EPA claim does not require intent. In fact, it can be seen as a strict liability statute, whereas in a discrimination or harassment claim, intent is a necessary legal element. Further, the statute of limitations for the EPA claim is not told while her discrimination and harassment claims are pending before the CHRO. So, the trial court erred in holding that the res judicata barred her gender discrimination claim brought under our Fair Employment Practices Act. Thank you, Your Honor.
All right, thank you both for participating in the virtual argument today. We will take the matter under advisement, and the court will stand adjourned until 9:30 tomorrow morning. Thank you both. Have a good evening.
You too, Your Honors.
Thank you.
Thank you.
Bye-bye.
Good night, everyone. Thank you, Your Honors.